here. There's a whole lot of other people, and let me tell you something, and I'll say this to you, and I don't have to raise my hand. I am not done with Zendo Kern and that whole incident before the Planning Commission. Now that he is the committee chair of the Planning Commission, I believe that that appointment smacks of conflict of interest. It's indecent, and that I hope and I swear hostility to it. So you all do your duty, because I'm telling you something. I got proof, and I don't want to spend my whole 2013 looking like some kind of fool out there to the community, only come back here and be vindicated by you. So I thank you for the leniency that you gave me on this. The other thing that I want to say is that number B, please do your best to sort it all out. Please do your best to sort it all out. Thank you very much.
Thank you, RJ.
Yes, I am emotional, but it's been a while.
The next item on the agenda is the review and approval of the regular session minutes of November 19, 2012. Are there any comments or corrections? All voters were able to vote, and there was no drive-through of cars that were turned away. The petitioner, RJ, if you could come forward, please. RJ, you had made some statements during the general discussion. Do you have anything you'd like to add at this point?
Well, to be brief, I tried to put all my points on one piece of paper, so I believe that I did ask, what I am asking of you is that you look into this. If for some reason intentional deception is exempt from the ethics code and or rules governing the council, it will be, in our opinion, a call into question the very credibility of the process. So I'm looking at, the reason we did this is because I actually believe that it was intentional, that even if it was a thing called, it's a thing in psychology that we call it in thought process called misremembering. And misremembering is a nice way of saying remembering incorrectly. And to give the councilman that kind of latitude to say that you misremembered it would have been okay. I know that now that he has lost the election, that this had an impact upon the people, and that the people are feeling the way they feel, and they took it to the voters' poll. But there was 2,000 other people out there that did continue to support Mr. Blas. And I need for those people who are still out there, and for the people who have been elected because of Mr. Blas's politics and the people surrounding him, that I plan to also build upon the case. This is not the end. This is only the beginning, because it was an incident and an event that triggered something that is systemically wrong with the 2010-2012 County Council. And so I don't want to get into that now. I will say to you that I really am looking for you all to set the standard. If I can't find it in the ethics code, anything about lying or this, and when I type in the very word lie or dishonesty or deception, and I don't find a word that even mentions these particular high standards. We're talking about Socrates here. We're talking about the very foundation of law. We're talking about, I don't want to get it. So if you get it, and I know Renee gets it, there's a resolution. There's something y'all can do to shore it up and to make a statement from this moment forward to the new councils, to the future councils, to anybody, that if you cross this line, you in trouble. So think about crossing that line. I gave up a radio show when I was legislative aide. I gave up all kinds of things to keep the appearance of no conflict of interest, so that if I had to come before you, I could defend myself with the truth. You see what I'm saying? And that is not what happened. The reason we have these election things and Dominic Yagong before us and the county councils because they had a low standard and they were desperate to get elected and they meddled in other people's district politics and they were all over the place with their special this and their special that. It all backfired. And you all saw it. Chairman Dill saw it. You saw it and you addressed it. And now everybody's back in the corners and trying to figure it all out and distance themselves from the cancer. Well, I took the shots in the newspaper calling Fred Blas a cancer, and I was right. And the cancer has metastasized. And so, therefore, it's going to take a radical treatment. And that's what I'm looking for you. So I'm looking for you all not to dismiss this because Fred left. But since he's not here, and he doesn't have to answer himself because it's on video and it's a matter of public record, that you should take it from here. And I would like to see you all put out an opinion, put out a warning, put out a standard that we can all set. Because you remember me, my boss was before you for throwing a pencil. My boss was before you for calling someone wacky. My boss was before you and splashed all over the newspaper. Don't tell me it's not political. But that didn't happen to Blas. Blas got a side thing over here and a back thing over there. So I know, and that's not your fault. But with all that I've just said, and I am raising my hand under oath, that the truth I tell you about the district politics in this community is the truth and nothing but the truth and not my opinion, but is hidden, and all the public transcripts for every goodie that they ever came to the council or the planning commission or anywhere and got. They're so stupid, Commissioner. These people are so inept that they are good to be caught to the point where a recall and an election and a new election may necessitate to set it all right. It'll make June 16, 2008, look, when they had to recuse, you had to do it all over again with the county council and all the laws that they had passed. It's going to pale in comparison if you do your job because there's a cancer and it's spreading. And now they've divided into 2 districts. I'm not going to let it go by. Thank you.
Thank you, RJ.
Ethics.
Does anybody here have any questions for RJ? RJ, I must say that I do agree that as an individual, that to come out and lie and to manipulate words, especially in a high position, is wrong. But I'm sorry to say, but we have, at least as far as my opinion, I'm going to refer to counsel for a minute. We no longer have jurisdiction over Mr. Blas. Counsel?
Mr. Chair, you're correct. The Hawaii County Code of Ethics only applies to officers and employees. Mr. Blas is no longer an officer and employee, so you don't have jurisdiction over him. Additionally, there is a Hawaii Supreme Court case entitled John Doe versus State Ethics Commission, 53 Hawaii 373, where the Supreme Court actually enjoined the Ethics Commission from considering a complaint, making an investigation, and prosecuting a charge with respect to an individual that is no longer employed by the state.
With that in mind and no longer having jurisdiction over Mr. Blas, even though we can agree with the type of statements and things that RJ has mentioned before us, the chair moves that we dismiss this petition based on having no jurisdiction over Mr. Blas. There's a second to the motion. Is there any discussion on this matter? Hearing no discussion, I'll call for a vote. All those in favor of the dismissal of petition number 2012-07 say aye. Aye. The decision is unanimous. Thank you, RJ. We'll move on to petition number 2012-08. If you can come forward. The petition is the initial review of petition alleging that a county officer violated Section 2-83B, unfair treatment of the Code of Ethics when the officer, in conspiracy with others, illegally obtained and used $10 million of the people's money for the sole advantage of Bank of Hawaii, First Hawaiian Bank, and or a RICO enterprise of the Old Boy Network and or unmentionables. Mr. Cole.
Yes, I believe I've been trying to bring this to the attention of this board since November the 8th of 2008. Unfortunately, Chairman Dill is not here. For I would remind him that currently there's an ongoing investigation out of the State Attorney General's Office and the Office of Information Practice, identified as S Investigation-G 10-1. As none of you will recall, because you weren't here, in June of 2009, I appeared before this board, only to find out that secret letters of extortion had been sent to board members prior to my appearance. And apparently information confidential to this board had been released to the public, where public statements were made prior to the board. So in order to caveat this, I would like to I ask any of you if you've received any letters of extortion or letters explaining or requesting you to make a certain decision, or if the decision has already been made prior to this meeting. This will be investigated and added to the current investigation as per my email from Lyndon Jostein, staff attorney of the OIP. Hearing none, I assume that you haven't made your decision or decided to recuse yourself from this meeting. I come before you, it is not a question, as I said before, of the criminal actions identified by Corporation Counsel Ishida. Corporation Counsel Ishida, in electronic verification of emails under the Uniform Information Practice Act, sent me the very documents of the issuance of the bonds, of the issuance of the IRS tax form exemption of bonds identifying $3 billion of refinancing bond Series B, issued me, gave me the copies of the actual bond issued with the cusp number bearing the signatures of Billy Kenoi and Nancy Crawford. The communications between Bank of Hawaii and County of Hawaii bearing the signatures of Michael Okamoto, the treasurer. Must be noted that Michael Okamoto, prior to becoming treasurer County of Hawaii in 2000, was a senior executive Bank of Hawaii. In continuing, the question before this board is one of ethics. Did Mayor Kenoi violate the ethics code by giving proprietary and sole proprietary access to assets of the people, identified as $10 million, that was obtained through the verified and defined illegal action by the very Corporation Counsel of the County of Hawaii in verification? I question the very fact that this could not have happened. Mayor Kenoi could not have sold $10 million of Series B bonds on March the 2nd of 2011 under the authorization of Bill 311 Draft 3, because Bill 311 Draft 3 had not been approved or authorized by the County Council. As required by the charter, all sales of bonds must be authorized by the Council. In response, Mr. Ishida, in electronic verification, did in fact confirm that the $10 million bonds were in fact sold prior to being authorized by the county. That is not a question of a fact here whatsoever. Okay. The question of the fact is, what value did the people of Hawaii get for the $66,000 they paid to Bank of Hawaii for the purpose of having that $10 million wire transferred from Bank of Hawaii on March the 2nd of 2011 to the First Hawaiian Bank on March the 2nd into bank account? And here's the exact deposit slip. Here's the exact bond sold with the cusp registration number as on file and held in New York Mellon Bank, 1 Wall Street, 3rd floor, window A. On March the 2nd, 2011, custom number 41969 CAE6 with a maturity date of September the 2nd, 2011. On that very same date, the money, $10 million, was used to open a certificate of time deposit, First Hawaiian Bank, account number 200100201, for a period of 184 days with a maturity date of September the 2nd, 2011, identical to the maturity date of this bond, March the 2nd, 2011, at an interest rate of 0.1225%, which is 1/10 the interest rate that the county of Hawaii, the people of Hawaii, were paying to Bank of Hawaii. I guess we'd make a profit on volume on this, wouldn't we? In addition, I was sent the actual copy of the bill with the signature of the mayor on it. Again we go, all right? Now, what we don't know, or what isn't said here, is the information I got is there's also a set of Series A bonds issued for $10 million. When questioned as to what happened to all the information of request offering of bonds, the County of Hawaii only offered bonds to Bank of Hawaii. The County of Hawaii did not offer bonds to any other financial organization to see if we could get a better rate. Okay, that in itself is a violation, but unfortunately, due to a bowling conflict on a team membership, that couldn't be heard by this council, apparently. Now, Chair Balser, excuse me, you are a financial manager, so you are very much aware of the violations of the Security Exchange Commissions, the state and federal laws on bank fraud. I have no point here. What I'm asking and what I'm requesting under the pureness of the jurisdiction of this body is to allow this case to go forward, this hearing to go forward into a formal hearing where individuals may be subpoenaed and sworn oath taken, where Mayor Kenoi may sit here before you, swear an oath, and tell the people of Hawaii why he sold $10 million worth of bonds without the authorization of council, why it was in the county's interest, in the people's interest that he was elected to support. How is it in their interest that Bank of Hawaii was able to use $10 million of their money at 1/8% interest while they were paying 1.25% interest? What value does it have to them? So I request that you approve this petition to go forward for a formal hearing so that rules of discovery under the Hawaii revised statutes and the court rules may proceed. However, I understand, and I would be terribly shocked if you actually went through, but I cannot understand that this committee or this board would allow this to go forward due to personal or the influence of racketeering and corruption and public corruption. Do you have any questions?
Are there any questions from any of the members of the board at this time? I have a question for you. You're referring to the sales of the bonds, and I remember not extremely specifically when the matter came up as to how the county structured the short-term monies before the long-term bonds were being purchased by others. Are you referring to the short-term bond, or are you referring to the long-term issuance?
That has no bearing here whatsoever. However, I will answer your question. The county charter states that under Section 6-6-1, Organization, Department of Finance, under section 6-6.3, powers, duties, and functions. Under C of that section, it states, negotiate loans and issuance and sale of bonds and notes when authorized by the council, maintain records of county indebtedness, and have charge of the payment and interest principal thereon.
Okay, so, but the question has to do with the, if I recall, there were two facilities that were structured by the County of Hawaii.
The facility of the sale of bonds was a traditional bond float. The sale of bond anticipation notes, by its very definition, is a short-term sale in anticipation of the sale of the bonds, and that was clearly defined in today's article in the Tribune Herald by Nancy Crawford.
And so,
Nancy Cook Laurel.
So the issue that you have is with the bond anticipation notes.
The issue I have is the fact that the bond anticipation notes were sold prior to the authorization. In other words, there were no bonds upon which you could sell an anticipation note to.
Where was the facility or was the facility approved in terms of a function that the county could go by?
No.
So what you're saying is the county council had absolutely no knowledge of the bond anticipation notes prior to that issue.
My discussion with Don
I'm not
McGee
talking
Gong,
about the specific transaction. But
my
I'm talking
discussion
about
with
the
Don
approval
McGee
of the
Gong,
facility.
he did not know that Mayor Kenoi had sold $10 million of bond anticipation notes prior to May the 4th when the bond was approved for sale. In other words, what you're trying to do, I believe what you're trying to do is say that in order to sell a bond anticipation note, you are selling a note in anticipation of a sale of a bond float, a general float. The anticipation note is used for basically arbitrage or for short-term monies needed for a project. If there has been no bond authorized for future sale, then the sale of a bond anticipation note upon an authorized bond cannot be sold legally. In other words, if the county did not approve the sale of the $56 million bond for the projects identified, then there would have been no bond upon which an anticipation note could be issued. In addition, the county explicitly and pointedly stated that the monies for the bond of Bill 311 Draft 3 were identified specifically for the projects. Therefore, the mayor must identify how or what specific project upon the authorization of the bond was used to justify buying a $10 million time deposit bond or time deposit note from the Bank of Hawaii. There is no authorization. It did not go to any approved use of the money. So therefore, it would be illegal on multiple counts. And since the money was not used as required for the specific bond issuance, in other words, what item of the bond, in fact, if you'd like to, I can read the actual bond here.
That'll be okay.
What item of the bond did the $10 million that the bond anticipation refinancing note Series B? Series B, I understand, is a refinancing note. Okay? So we have never issued a Series A, apparently, because I found out they said it was a typo. And Bank of Hawaii issued the County of Hawaii $10 million loan on a typo. That stretches my imagination. So not only do we have to determine what value the people of Hawaii got for their $66,000 interest, but what item of Bill 311 did in fact the bond anticipation note be issued for? That can never be answered either because there was no authorization.
Any comments or questions from the rest of the board? Is there any thoughts of where we shall proceed with this?
Mr. Cole.
Yes.
The documents you refer to, Bill 311, and the email from Lincoln Ashida.
Emails from Lincoln Ashida, yes.
Did you submit any copies of that?
Yes, I have. In fact, if you look at my petition, I actually had presented those to you in public. And you had received those documents numerous times, as a matter of fact. I think I actually stated here are the documents that I prove this, and I have issued them to you, I think. Okay, let's see what we got here. In fact, I refer to page 2 of the minutes of the regular session of Wednesday, July the 11th to 12, where I state, quote, "Here's the exact illegal bonds being sold by the mayor and Nancy Crawford, the deposit slip from the Bank of Hawaii to First Hawaiian Bank, the return of principal of the First Hawaiian Bank, and the federal IRS forms of tax-free obligation." They're on file with your board here. So if you review your the actual filings and the testimony I've made, you will see all these are in there. You will also notice that they're also in there, and as identified, from my petition for Nancy Crawford. So you are well aware of all this information. However, if you'd like more copies, we can have them electronically transferred to you, but this should be brought up in a formal hearing.
I wanted to point out, I believe the reason we don't have that right at this time, when they were submitted in the past, and please correct me if I'm wrong on this, the matter previously was specific, whether or not there were conflicts of interest in deciding who the vendors were going to be with regards to the facility for the anticipation bonds and anticipation notes, excuse me. Mm-hmm. And so what had happened is one issue, but looking at how the vendors were selected was the issue at hand at that time. So at that time, you may have not looked at that particular aspect of the transaction. And so now you're asking us to look at the specific transaction to determine legality or illegality.
No, the legality or illegality is not the jurisdiction of this board.
Correct.
The legality or illegality would be held with the county council if they determined that there was sufficient grounds for a misdemeanor violation of the Hawaii County Charter. It is the county council's obligation to file a criminal complaint. What I am asking before this board is what value, what did the people of Hawaii get for the $10 million that Mayor Kenoi gave to and proprietary to the First Hawaiian Bank? The people of Hawaii paid $66,000. This is no difference than if Mayor Kenoi decided to use $10 million of heavy equipment from the Highways Division and $66,000 worth of manpower and fuel to clear his subdivision that suddenly got approved when he appointed the new planning director. There is no difference. This is what did the people of Hawaii get in return for their $66,000 that the First Hawaiian Bank had proprietary use of. Proprietary use. This is not the illegal, this is the ethics board. So that's why I'm requesting. In discovery before the ethics board, in formal hearings and subpoenas, it will come out any violations or criminal violations. That would be the purview to be forwarded on under the United States Code, Criminal Section 18, subsection 4, misprision of felony, that you are obligated to do. However, the ethics complaint merely states that already have been denied many times.
Counsel, can we just simply request an answer to that question?
Well, Mr. Cole brought up the fact that he had brought similar allegations against Nancy Crawford last time, and I believe the petition was filed in early 2011, and substantially similar allegations with respect to the bonds.
They are not similar allegations, Councilman.
Testimony was provided, and the board did dismiss this matter. So if you, want to review those minutes, you want to review the order dismissing, we can provide you with that, or whatever other questions you have.
Council is in error. That is not what the petition for Nancy Crawford was about. The petition for Nancy Crawford.
Yeah, I understand.
Yes, okay.
I would like to review those. What I would like to do is very simply ask the mayor's office, and they can submit in writing. Nobody has to show up. I want to find out the benefits. We're looking at the benefits of that transaction. Period.
Okay, can you spell out what transaction specifically so that I can formulate a question?
Yes, it would be easier for me to write it down and give it to you.
Okay, so you're asking for to continue this initial review of the petition?
Just a continuance of the initial review. Do I hear a motion to go with that? A second? All those in favor? Aye. Okay. So we're going to continue to get an answer from the mayor's office on that. I think at this point we can move on to the next agenda item. Thank you, Mr. Cole. The next agenda item is 4C, petition number 2012-09, employee's request for an informal advisory opinion on whether he may work as an independent contractor providing social work services for an agency providing case management services to individuals with disabilities and the elderly. And I believe that is from Mr. Ellwood Kita. Mr. Kita?
Yes.
Yes.
Morning.
You have the floor.
Actually, I submitted
Your letter?
in my letter, and I guess the concern was raised because somebody had approached my administrator, the executive on aging, Alan Parker, about a potential conflict of interest. It wasn't clear if it was specific to my situation, but since I did have outside employment, I did indicate that I would be willing to have this reviewed. If not for the present, at least it'll kind of set some standard for myself and if there are other employees in the office with outside employment.
Are there any questions from anyone?
Okay. Under the Office of Aging, there is a service, the Aging and Disability Resource Center, and part of what the Office of Aging administers is an information and referral service, and part of the service is by telephone calls or by internet or mail or walk-ins. So individuals come, they present questions or problems, and we try to advise them as to what may be available resources or programs for them. It would actually be, I wouldn't refer, I would offer information on providers, and it would not be myself, it would be named I would have been contracted by one of the providers. Right. Okay. I would provide them information so they could choose. And I would not identify myself as being related to any of the providers. But you are correct.
So then the provider would then say you tell the person go to X provider, then the X provider may retain you to provide that service? Is that what you're saying?
Yes. Well, actually, I would say there are provider A, B, C, and D. I provide you an actual list of the providers and the contact information. And they can decide to pursue it if they're interested in receiving that service.
Okay.
Yeah, and I am contracted by one of those providers. I was contracted in the past. Mm-hmm. And or at least an appearance of an advantage.
Yeah, I think what you're trying to say is that while you are giving an individual options, which is the appropriate way to do things, one of the organizations is an organization which perhaps could contract you.
Correct.
And while you are saying, and I have no reason to disbelieve you, that you are being objective in the presentation of these options, there can be the perception of propriety when you present the options.
That could be.
And I think that's the issue. And that perception of propriety is not a good thing.
Somewhat.
Go ahead, Counsel.
I guess I wanted to point the board to the Hawaii County Code, the Fair Treatment section and the Conflict of Interest section. The operative terms used in both of those sections are use of the officer or employee's official position, or if you are taking any type of official action. Okay, so in the conflict of interest provision, it says, no officer or employee shall take any official action directly affecting a business or other undertaking in which that officer or employee has a substantial financial interest, or in a private undertaking in which the officer or employee is engaged as legal counsel, advisor, consultant, representative, or other agency capacity. So it would be the use of your official position or taking official action over something that you would benefit from.
But I think what Arnie's saying is that by virtue of you presenting these options, and one of the options being the organization for which you also do consulting, if that would be the possibility of influence, especially in that perception. The question I have is, has this been previously discussed with your superiors, and what has been the reaction of that?
I don't think we discussed it directly, but my superior was aware that I did do some outside contracting.
If I'm to give advice at this point in time, my advice would be for you to have a formal meeting with your superior, perhaps another person in the room at the same time, just to make sure there's clarity of whatever discussion comes about, and come up with a methodology whereby there would no longer be a perception of how you present options. Perhaps someone else at that point in time comes in to present options. But that discussion in terms of procedures and processes would, I think at this point, need to be between yourself and your superior in order to eliminate perceptions of impropriety.
When I look over at all of the supervisors, one thing to keep in mind when you look at is your position with the county giving you an advantage over anybody else that's contracting on the other end with those providers. If you have any kind of advantage because of your position with the county, be very careful. Whether it be an advantage of influence, or you kind of owe me because I did this for you, kind of advantage, something like that. You know what I mean? So if you see any of that there, any of them, then you probably know where you're at.
Well, there may be a perception, but I guess that would be the concern.
You know, what this perception usually means that it's actually something there.
What you want to do is you want to eliminate that perception of impropriety. So I don't think anyone here is saying that there is impropriety.
I don't think you know enough about it to see an operation that says this in
Board members, that's actually the difficulty I think the board is having, is that it's not specific, so it's difficult to say doing this does violate the code. So if you could come back and be more specific, like I see that you say in a few instances 3 to 4 times a year you provide backup, in which case you then refer. I mean, there could be a situation where you don't ever do that, and then your side business may be permissible. So I think you have to be a little bit more specific for the board.
Yeah, I think overall what we're doing is kind of compromise here, and we put together is like you said, code between the supervisors, discuss it with the supervisor, and between the two you'll come up with a more concise statement of what actually is going on, and maybe we can see I just couldn't see it.
They may be able to resolve it themselves without even having to come back. But I think the issue is sitting down with your supervisor while he's aware of it. It needs to be addressed directly with him so that there's a direct awareness and that there's a meeting of the minds and all that.
Some of the problems that we don't know about, and then put it in writing so we can look at it.
You know,
We don't have a good grasp of this question right now.
I guess in the past, when other officers or employees have come before the board, they have actually brought their superiors and said, I've discussed it with them. These are the steps and measures we're taking to void even the appearance of impropriety. Board, is this okay? Then it's more clear that you have worked out everything, and then the board can see a clearer picture. So right now, you coming and saying, well, he knows about it, it's a little bit difficult. So that's what the board has done in the past.
Question to the council. Does this county have a supplemental employment policy or rule like the state does?
Not an overall county policy. There are some departments that prohibit certain employees from, conducting the same sort of business that they do in their official position, but no overall county policy.
I would think that they should have a overall to give General Mr. Kita a guideline as to what they can do and what they cannot do, like the state does. I come from the state side, not the county. And with that guidelines, a lot of these questions will be eliminated. So who would be responsible to originate this kind of rules? Because I've sat here with many times of attendance, management, accountability. And my question always comes back is, does a county address each of these issues? If there was a set rules or policies, none of this would come up. And the perception, like the folks were talking about, wouldn't be there because it's in black and white. So I don't know. I'm confused as to who's supposed to do it. I don't know.
Well, I think in terms of, even though there is no countywide policy in this type of situation, I think actually your code of ethics would be the guiding policy, because it does speak to, which is substantially similar to the State Ethics Commission. The State Ethics Code. And it talks about taking official action in a business in which you have substantial financial interest. So to me, that means if you don't have a substantial financial interest, then you can. But policy-wise, in the example you gave on attendance, that was more of a council issue on whether or not they had rules regarding attendance.
The only reasons I ask this question is, as a manager of any department, any division, or whatever you may call it, the employee is under my control if I'm the head. And if the employee comes up to me and asks me like a supplemental employment, I should have the ability to come out and just say, these are what you can and cannot be employed in. And the ethics will show you that so much reasons. But to me, there's more reasons than that also. And that's why I bring up that question.
I think at this time there's no specific opinion that the Board of Ethics can provide to you. I believe we've given some advice. The first thing is talk to your supervisor very specifically and directly and openly about your situation, so that there's full awareness in your workplace, and if there's a need to change a procedure or not to do something or to do something, then that can be taken care of, so there is no appearance of impropriety. The other thing is, as there are certain codes, not just the Code of Ethics, but also policies and procedures on a personnel basis in your section of the county, check them out to see if there's something very specific about this. And then if you have further questions, then you'd be able to come back with specifics and with your supervisor.
Okay, thank you. I think maybe the most prudent action for me is to just refrain from outside employment for the present.
Correct.
And before, and if I consider it again to have a better presentation to this board. But also in the meantime, I will speak with my administrator, because there may be other employees who may be involved with outside employment, and there may be at least a perception of a conflict. So I will work with my administrator on that.
Excellent. Thank you very much.
Thank you.
You're finished. Thank you, Mr. Kita. We're now moved on to unfinished business, and the first, I'm sorry? Oh, I'm sorry. Council's report regarding matters and/or inquiries received by the board, including gift disclosure, statements received from Allison Lee and Lester Cito of the Workforce Investment Board disclosing the no receipt of gifts. Council?
Nothing further. We just received these two statements and no gifts were reported.
Duly noted. Moving on to unfinished business, petition number 2012-03. The review of the draft order dismissing petition submitted by Cheryl King, which alleged violations of section 2-83 of the Ethics Code when county employees were allowed to attend union meetings on county time in which political campaigning took place. Have all the members of the board present today have an opportunity to review the order dismissing this petition? Are there any comments or questions, additions, deletions? Are there any motions to be presented at this time? Do I hear a motion to approve the petition? It has been moved. Now I'll call for a vote. All those in favor of dismissing the petition say aye. Aye. The vote is unanimous.
Yeah.
That is correct, to approve the order dismissing the petition. The next item on the agenda is petition number 2012-04, review draft order dismissing petition submitted by Tiffany Edwards Hunt, which alleged that County Clerk Jamae Kawauchi has been very selective in dissemination of public information and showed preferential treatment to certain reporters and stonewalling others. In violation of section 2-83A(3) of the Code of Ethics, that all persons shall be treated in a courteous, fair, and impartial manner. Has everyone had the opportunity to review the order dismissing this position? Are there any questions or deletions or additions or whatever? Do I hear a motion to approve this order dismissing the petition? It has been moved and seconded to approve the order dismissing the petition. All those in favor? Aye. The decision is unanimous. The order for dismissing this petition has been approved. At this time, do I hear a motion to go into executive session to review our minutes of the last meeting and to review confidential financial disclosure forms? It's been moved and seconded to go into executive session. All those in favor? Aye. It's unanimous. We're now going into executive session.